Now we will see the next questions. So this question was asked in 2019. So the question says, the ninth schedule was introduced in the Constitution of India during the Prime Ministership of. So this is a very factual question. This is asking about the Prime Ministership. So as we all know that ninth schedule was not in the original constitutions. So it was added later by the first Constitutional Amendment Act in 1951. Clear? So during this period, the Prime Minister was Pandit Jawaharlal Nehru. So this is very factual and very easy question. So answer to this question is Pandit Jawaharlal Nehru. Direct questions we can say. Now if you see the about the ninth schedule, so ninth schedule is giving a protections from the judicial review, that is originally when this was formed. So this was giving an protections. The courts were not allowed to interfere, or the courts were, it is beyond the challenges. It cannot be challenged in the court for the violating fundamental rights. Originally it was meant to protect land reforms from being challenged. Initially focused on land reforms, abolition, that is abolition of zamindari systems. Over the times, laws covering reservations, economic policies and other reforms were added. It now contains more than 280 laws, right? If you see the letter, the judiciary has interpreted, and through the ruling of a Supreme Court like Keswanand Bharti case, which says that the basic structure doctrine was established and limiting Parliament's power to amend the constitutions. In the Vaman Rao case in 1981, the Supreme Court ruled that the laws added to the ninth schedule after 24th April 1973 are subject to judicial review if they violates the basic structure of the constitutions. So initially, the ninth schedule gave protections from judicial review, but after the propounding of the theory, doctrine of basic structure, the Vaman Rao said that it will be now, it is applicable prospectively, not in retrospectively. Applications of this judgment will be in the ninth schedule. Clear? So through a IR Collier case, which is also known as a ninth schedule case, the Supreme Court ruled that even laws under the ninth schedule can be reviewed if they violate fundamental rights and basic structure. So this is the some summaries of ninth schedule. Clear? Let's move to the next question. So next question was asked in 2019, and it says, the question says that under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void, right? So tribal land, talking about the transferring of tribal land which cannot be allowed. So as we know, there are only two schedules, fifth and sixth schedule, which are related to the administration of scheduled areas and tribal areas. Clear? So now let's see the options. So is the answer is third? No, third is not. Third is related to oath and affirmations. Clear? Fifth schedule, yes, fifth schedule is the answer because it is related to administration of scheduled area. Ninth schedule, as we have seen in the last question, this is related to land law, land act, so it cannot be the answer. 12th schedule also cannot be the answer because it is related to the municipality. So answer to these questions is B, that is fifth schedule, which deals with the administrations of scheduled areas and tribal areas, and whereas the sixth schedule deals with the administrations of scheduled area and tribal area in 4 states, that is Assam, Meghalaya, Mizoram and Tripura. So these are the 4 states which administrations is dealt in 6th schedule. Clear? So if you see the explanations, So it says that the third schedule of Indian constitutions contained oath and affirmations for various constitutional positions in country, like oath of office of ministers for union, oath of secrecy for ministers of the union, oath or affirmation to be made by the candidate for election to parliament or state legislature, oath or affirmation to be made by the judges of Supreme Court and High Court, Comptroller and Auditor General of India. Fifth schedule provides special protections for the tribal land to prevent alienations, that is of selling or transferring land to non-tribal. So governor of the state with scheduled area have a special power to regulate and restrict land transfer between tribals and non-tribals. So the power is given to governors. This is done to protect the rights of indigenous tribal communities and prevent land encroachment. Right? This is just to prevent their land rights. Ninth schedule of the Indian Constitution is added by the first Constitutional Amendment Act 1951 to protect certain laws from judicial review, primarily related to land reforms and socio-economic policies like zamindari systems, abolitions of zamindari systems. We have seen it. So the 12th schedule were added to the Indian Constitution by the 74th Amendment Act 1992. It defines the functional responsibility of urban local self-government such as municipalities, municipal corporations and Nagar Panchayat to strengthen urban governance and decentralizations. So this 12th schedule is related to municipalities and urban local self-government. Clear? So let's move to the next questions. Next question was asked in 2018 and the question says consider the following statement. So the two statement has been given. Now let's analyze the given two statements. So the first statement says the Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Yes, it is true. Right? As we have recently seen back to questions about the 9th schedule. So it was introduced by the first Constitutional Amendment Act 1951 and this is related to the Land Act. So the Parliament of India has a power to place a particular law in the 9th schedule. Not only the Parliament but also along with the Parliament, state legislature can also do that. State legislature can also put particular law into the 9th schedule. So first is true. So if you see the B cannot be the answer and D cannot be the answer. Now if we see the second statement, so second said the validity of law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. So it means that the second wants to say that it is outside the preview of judicial review. Judiciary has no power to review the laws made under the 9th schedule. So in the today's scenario, it is incorrect. But when it was initially formed, when it was initially introduced, that is in 1951. So for that period, this was 9th schedule. 9th schedule was kept outside the preview of judicial review. But in 1973, through the Keswan and Bharti case, when a doctrine of basic structure came, so this and the judicial review came under the doctrine of basic structure. So because of being a judicial review, being a doctrine of basic structure, it cannot be denied. So in the IR Collier case, which is also known as a 9th schedule case, which has given a statement that the 9th schedule is not outside the preview of judicial review. So in the today context, yes, it is incorrect. If it was in the originally it was made outside the preview examination of the court. So in the today's context, it is incorrect. So we can say that C cannot be the answer. The answer to this question is A, that is only 1. Now if you see the explanations to these questions. So it says that the 9th schedule was added to the Constitution by first amendment in 1951 along with Article 31B with a view to provide protective umbrella to land reforms law to save them from being challenged in a court on the ground of violation of fundamental rights. The Supreme Court upheld the validity of Article 31B and Parliament's power to place a particular law in the 9th schedule. Initially, law in the 9th schedule were immune from the judicial review due to Article 31B, meaning court could not examine their constitutionality. However, in the I.R. Collier case versus State of Tamil Nadu in 2007, this is also known as a ninth schedule case. The Supreme Court ruled that even law placed in the ninth schedule after the 24th of January 1973, and this date is important because on the same date the Keswan and Bharti case was judgment came and a doctrine of basic structure was propounded. So it says that even law placed in the ninth schedule after 24 January 1973 can be reviewed if they violate the basic structure of the constitutions as laid down in Keswan and Bharti case, which means that law in the ninth schedule are not automatically immune from judicial review, especially if they violate the fundamental rights. So any law which is to be kept in the ninth schedule after the theories of doctrine of basic structure judgment and the Keswan and the Bharti case came 24 January 73, so that will be came into challenge. But before any law made before that, it means this theory of doctrine of basic structure cannot be applicable to retrospective. It is not retrospective. It is prospective. Clear? Okay. Let's move to the next question. Next question was asked in 2015. So the question says, provision in 5th schedule and 6th schedule in the Constitution of India are made to. Now we have seen many times that 5th and 6th schedule is talking about the administration of scheduled area and tribal area. So this is to the scheduled area and tribal area. 6th schedule is also talking about the administration of scheduled area, but in the 4 states of northeast state. Clear? Now let's see the options. What are the options available? So it says the provisions in the 5th schedule and 6th schedule in the Constitution of India are made to in order. Now the reason behind objective, basically it is asking about the objective, and we know this is the objective of these two are to protect the interest of the scheduled tribes. So it says to protect the interest of the scheduled tribes. Yes, it is true. Determine the boundaries between the states. No, it is not determining the boundaries. Determining the power, authorities and responsibility of panchayat. No, it is also not determining the power, authority and responsibility panchayat, though this was been done through the 11th schedule, we can say that, not through the 5th or 6th schedule. Protect the interest of all the border states. No, this is also not doing so, or this is also not been given by the administration. So answer to this questions is can be and stated by that A, that to protect interest of scheduled area and scheduled areas. Now if you see the explanations to this question, it says the 5th schedule of the Indian constitutions provides special provisions for the administrations and governance of scheduled area and scheduled tribes in mainland except northern state, which are covered under the 6th schedule. So scheduled area, what are scheduled areas? So scheduled areas are declared by the President of India in consultations with the state government. These areas have a high tribal populations and require special protections. The governor of the state has a power to make regulations for peace and good governance. So area declared by President of India but managed by the or regulated by the governor. So there is a tribal advisory council related to the 5th schedule, which says that each state with scheduled area have a tribal advisory council, right? The council consists of 20 members, at least 3/4 of being scheduled tribes, representative from the assembly, advises the governor on matter related to tribal welfare and administration. So tribal advisory, as the name suggests, this is a council for tribals, which is a responsibility of to advise. Clear? So advise. So as its nature suggests, to advise. Now, so it will advise the governor, advising on welfare and administration of the tribal area. Now, if you see the Governor's positions with respect to the fifth schedule. So governor can make regulations to prohibit or restrict land transfer in the scheduled area. Governor can modify or annul any law passed by the state legislature if it affects a scheduled tribe. So the state laws will only applicable into the scheduled area under fifth if it is only allowed by the governor. Right? Governor reports annually to the president on the administration of these state. So role of president and parliament with respect to the fifth schedule. So the president can direct the application of laws in the scheduled areas. Parliament can amend the schedule to include or remove scheduled areas. Clear? Now if you see the significance of the fifth schedule, so it protects tribal lands and tribal land and rights from exploitations. It ensures tribal welfare and development through special governance structure. It empowers governors to make law suited for tribal regions and promote self-governance and safeguarding tribal culture. So this is fifth schedule. Now if you see the sixth schedule of the constitution, so sixth of the constitution provides special provisions for administration of tribal areas in the northeastern state of Assam, Meghalaya, Tripura and Mizoram. It was included to protect the rights and autonomy of indigenous tribal communities in these regions, right? So these basically are the indigenous tribal communities. So there is an autonomous district council under sixth schedule. So advisory tribal council in fifth schedule and autonomous district council in the sixth schedule. So schedule provides for the creation of autonomous district council in tribal areas. These councils have legislative. So these councils have legislative, administrative and judicial power over certain matters. Now if you see the power of autonomous district council, they have a legislation power. They can make laws on land, forest, water resource, agriculture, village administrations. They have a power of taxations, so they can levy and collect taxes, fees, tolls for local government. They have also the judicial power, like they have an authority to establish courts to settle tribal disputes. Now if you see the structure of autonomous districts, so each council consists of 30 members, some elected and some nominated. The governor has the power to oversee and modify council's decisions. If you see the governor rules with respect to the sixth schedule, so governor has a discretionary power to increase or decrease the jurisdiction of advisory autonomous district council and can appoint commissions to examine the administration of the tribal areas. So this is the role. Now if you see the significance, so it is also protecting tribal culture, land and autonomy. So both of these fifth and sixth schedules were meant to protect the interest of the scheduled tribes, right? It is promoting self-governance for indigenous community, ensure development in remote tribal areas and prevent exploitations of tribals' land and resources. So these are the explanations to the questions which talks about the objective. So here we have seen the objective of the fifth and sixth schedule. Clear? Let's move to the next question. So next question was asked in 2014. It says that which one of the following schedule of the Constitution of India contains provision relating to anti-defections law? Right? This is an anti-defections law. So does this contain in second schedule? The second schedule talks about the salaries and allowances. So answer cannot be the second schedule. Let us talk in the fifth schedule. Now we have seen the fifth schedule is an administrations of scheduled areas and tribal areas. So this is cannot be the answer. Eighth schedule is about the official language. So this cannot be the answer. 10th schedule, so left is only the options we have left is the 10th schedule. So answer to this question is 10th schedule, that is of the anti-defections, and this was added by the 52nd Constitutional Amendment Act 1985, and this talks about an anti-defections or 10 schedules. Now if you see the explanations to these questions, so the second schedule of the Indian Constitutions contain provisions related to the salaries, allowance, provisions of key constitutional authority in India. It ensures financial independence for these officials, preventing undue influence and safeguarding integrity of governance. The fifth schedule of Indian Constitution provides special provisions for the administrations and governance of scheduled areas and scheduled tribes in the mainland. The eighth schedule of the Indian Constitutions deal with languages recognized by the constitutions. It lists official language that the government can use for administration, administrative, legislative and other official purpose. The 10th schedule of the Indian Constitution, also known as Anti-Defection Law, added by the 52nd Constitutional Amendment Act 1985, it lays down the provisions to prevent political defections by member of parliament and member of legislative assemblies to ensure political stability and prevent unethical party switching. So this is the questions asked in 24. And by this we come to an end to the topic of scheduled related questions in the examinations, right? So hope this will help you to prepare your exams, and I will request you all to please subscribe, like and make some comment also what else you want, how you are liking the videos, how it is helping you in your preparations, and also forward to your friends so they can also get benefit. Clear? Thank you and best of luck.